taken, or rather we labeled the two volumes. Did we say MK1 and MK2?
We had said both are MK1.
Oh, both are MK1.
Yes.
I just thought we have an annexure that is
That's a
MK1
problem.
inside. So I'm just thinking maybe for all the volumes that we are going to have, let's use the surnames of the witnesses.
Okay.
So let's just call this one Mkwanazi 1.
So technically it will be volume 1, then
Yes.
volume 1 equals General Mkwanazi, and then the volume 2 will be for the next witness.
Didn't you say we call it 1, both of them, or what?
No, I'm saying then volume 2 will be
Yes.
picked up by the following witness.
Oh, all right.
So
Yes.
volume 1, regardless of the number of arch lever files that make up the volume, that constitutes volume 1, General Mkwanazi.
I think it doesn't matter if we have volume 1 in respect of each witness.
Yes.
So this one is just Mkwanazi 1.
Okay.
Another one down the line may be Masemula 1. So we can have 100 ones,
Okay.
as long as we identify each one of them by surname.
By surname.
We will not get lost.
We hope not to once
I
the
don't
volume
think we will.
increases. But we will, for the moment, we will follow that approach.
We won't get lost, no. Thank you very much.
Thank you, Chair.
Good morning, General. You are still under oath. Thank you.
Thank you, Chair. Good morning, General.
Good morning. Good morning, Commissioner.
General, when we parted yesterday, Commissioner Khumalo had posed a question to us regarding some aspects that we had already covered. And you recall that we undertook to answer that question when we start today, before we continue with your testimony. And I propose that we do so now. And Commissioner Khumalo will correct me if I misquote him, but sorry, I got distracted. The gentleman behind me keeps talking, so it's distracting. If I understood his question correctly, Commissioner Khumalo wanted to understand, in respect to the 121 dockets, and I guess for lack of a better phrase, the ownership of those dockets. He wanted to understand whether the dockets that we reference as Eastern Cape dockets are owned by the task team, or they are owned by, let's say, the Eastern Cape Police Service, if I understood the question.
I understood the question differently,
Okay.
but let me let my colleague...
Thank you.
Thank you, Chair. The first question, good morning, General Mkwanazi.
Good morning, Commissioner.
Yes. You will recall that, and then maybe while we are at it, Advocate Silo, we should just clarify the letter from the Minister.
Yes.
Containing the directive to disband the task team.
Yes.
We kept referring to it as the 2 January 2025 letter. It is in fact dated 31 December.
Indeed, Commissioner, it's the 31st of
Yes.
December. 2 January is when he learned of it.
When General
Yes.
Mkwanazi first learned of the letter.
Indeed.
Yes, and what I tried to understand or establish, General Mkwanazi, is your understanding of the instruction to disband the task team and what became of the task team. In other words, the members of the task team subsequent to the instruction to disband it. Did they all go back to their stations or to their provinces? What became after you became aware of the instruction?
Thank you, Commissioner. Commissioner, as I said yesterday, that the instruction was not officially given to me. It will have been sent to the National Commissioner. And National Commissioner did not communicate anything to me. But what I know of is that the team continued working. It never stopped. However, the numbers of members that were deployed in the team were reduced. Now, the reason of the perhaps reduction of the total number of personnel deployed might have been influenced by the budget. might have been influenced by the budget, but I guess the Judicial Commission is in a better position to explain what led into the reduction in terms of the number of personnel. So there's quite a lot of police officers that withdrew and went back to their stations, whereas others remained.
All right. So if I understand you correctly, until there was official communication to you from the National Commissioner, you did not take steps to disband the task team?
That's correct. I did not take steps to disband the task team to date.
Thank you.
And perhaps then, and thank you for the clarification, it is an aspect that we were going to cover, might as well then complete it. To give a sense of the timeline, as we understand things, the letter is dated the 31st of December 2024, and it is dispatched to the office of General Masemola as the National Commissioner on the same date. The General becomes aware of it on the 2nd of January. He thereafter contacted General Masemola, and General Masemola indicated that he did not participate or contribute to that letter, and that in fact he had been away until the 14th of January. In the interim, a letter is dispatched by General Sibia that we referred to of the 4th of February 2025. And we dealt with this letter. There are two of them, the 4th of February 2025 and then one for the 24th of April 2025. In that period, there were engagements, as the witness testified, regarding the possibility of possibly reversing the decision. So in the meantime, the work continues, and up until April, the task team still has its files. You will recall that the witness indicated yesterday that for this period, they were approved 3 months of budget. And that was to run in this time, in this unclear time, until recently then the budget for the entire year was approved. I'm not going to testify and answer whether it existed, and I would like to park it there because we are going to lead into other evidence where we demonstrate the confusion that then reigned as to whether is the task team in existence, is the task team not in existence. You will recall in his evidence yesterday, General Mkhwanazi indicated that from his perspective, he didn't believe the minister had the authority to disband. So everything is up in the air, but I think by lunchtime we'll have successfully demonstrated what confusion reigned, and whether or not it was disbanded, I believe at the end of the day becomes a legal question for us to argue. Thank you. Maybe if I check with the commissioners, last night in our preparation, we had understood that perhaps we rushed through the question of the dockets. And I don't know if you'd like us to, we're thinking to recap on that before we move to the next point.
We are in your hands.
Oh, okay.
You know best what you want to do and what you want to achieve.
It would be for your benefit, but it is important then, I think, that the commissioners understand the whole issue of dockets, the impact of the removal of dockets, which in turn feeds into the very question that the Commissioner Khumalo has posed, that being, the latter being the bigger question. For this purpose, I would like to project what was put up, yes, during
yesterday, I complained privately, of course, about the fact that my co-commissioners don't have these monitors. I do have one in front of me. My co-commissioners should have those as well. They should not be expected
Indeed.
to turn and look across there.
and we do this on the assumption.
May I plead with the Secretariat that this should be attended to. Of course, I did not talk to you, Commission Secretary, so I'm not blaming you. Thank you.
Yeah, thank you, Chair. And I'm sorry I didn't check. Following discussion after the first hearing, the assumption was that the equipment has since been provided and therefore they will have. And I do apologize that we are here, but I think this is the only slide that we'll have to project for today. Yes. Thank you, Chair. And I was giving the Chair the assurance that I think it's the only slide that we'd have to project. The next one would be tomorrow, and I hope the problem would be resolved by tomorrow. General, if I may ask you to refer to your statement in volume 1, and in particular to paragraph 87. We dealt with the contents of paragraph 87 yesterday, and there you give a breakdown of the dockets as you classify them, 90 parallel cases, and you talk of ad hoc cases, University of Fort Hare, and traditional leaders' investigations. Yesterday, when the evidence leader, the chief evidence leader, made his opening address, he put up this slide. And on this slide, he indicated, he made a point under the date of the 26th of March 2025, that on that date, 118 dockets were handed over on the instruction of General Sibia, and on the 10th of April, an additional 3 were handed over, and bringing the total to 121. So I want us to start the conversation from there, and you explain in the context of what's on the screen, whether or not what is happening there, why we ended up handing them over in 2 batches, and what is the ownership, quote unquote, of what you term the Eastern Cape dockets. Thank you.
Thank you, Commissioner. It's a limitation from me to explain in details as to the movement of these dockets to the head office, because I was not the one that moved them. I believe that the investigating team who handed the dockets to the head office will perhaps come before the commission so that they can explain the whole process that they followed, including the scanning of the document prior to handing over and the audit that they conducted when they received them going back. My involvement, commissioners, is when I first received a briefing in May that the docket are already in Pretoria. And the briefing I received, which I referred to in my statement, is that 121 dockets are in Pretoria. So it was not necessarily explained that they went in patches. So it was said 121 dockets are already in Pretoria. And when I asked as to who directed that, and the response was from Kellen Matlow, was that Gerald Kumalo is the one who ordered that those dockets must come up. So the people that facilitated that move, I think they are better positioned to explain. My involvement only is limited to the briefing I get and the inquiry started making thereafter.
Thank you for that, General, and I appreciate
Your microphone is off.
I apologize. Thank you for that clarification, and your limitations are appreciated. Perhaps then we could turn to the question of the Eastern Cape dockets. We tend to refer to them as Eastern Cape dockets. We appreciated from your evidence yesterday that the mandate of the task team was extended by the President to include investigations into the Fort Hare killings. Am I correct?
That's correct.
So can you at least explain to the Commission, insofar as the task team is concerned, what is the status of the Eastern Cape dockets? Are they the task team dockets, quote unquote, or what is the real situation there?
As I explained again yesterday, Commissioner, in terms of the ownership of a case docket, it is a police station where the docket was registered. So in this instance, those dockets belong to police stations in the Eastern Cape. Therefore, they fall under the jurisdiction of the Provincial Commission Eastern Cape. However, because there is a directive that a team must conduct that investigations, which means therefore the team have to account for those dockets. They go to the police station, they take over those dockets, and they conduct investigation, but they must update a system which is accounted for at the police station, because the performance of the docket has to be reflected at the police station, regardless of where the docket is. So the team, they are responsible for the docket for the period of the investigation. Until investigation is complete, then they give the docket back. So in terms of the role that the team then plays in this regard is a temporal ownership of the docket in as far as the work they are busy doing. But as soon as they complete the work, then they transfer the docket back so that it gets to be filed and it's accounted for at that particular station.
Thank you. Now, on the return of these dockets, you deal with that at your paragraph 141 and 142 of your statement. You referenced yesterday an analysis that was conducted on those dockets when they were received back from head office. Can you briefly take us through the process of what subsequently became your understanding, what the team did with the dockets prior to handing them over, and the analysis that was conducted when they were returned?
Commissioner, as I indicated, the movement of the docket to Pretoria did not involve me. But through my inquiry from the team, I was informed that they had scanned every single docket before handing it over, so that they keep record of the status of those dockets when they handed them over. I get involved when the docket has to come back to KZN. And my involvement is started with a meeting that was held between myself, the acting divisional commissioner of detective services, as well as General Kumalo, and my deputy provincial commissioner, acting Major General Gopal. So we had a meeting, all of us, where we discussed how we're going to handle the process of receiving the dockets back. So from that meeting, the agreement that we reached is what we did thereafter, which was to have the very same team responsible from the political killings task team to hand over the docket, those that has a database of the status of the docket as they handed them over, to come over to Pretoria and meet up with detective services who are in possession of those dockets and go through every single page of the dockets, meaning auditing the status of the docket as they are still in Pretoria versus the status of the docket as per the scanned copies that they had in their possession. Just to cross-reference to check whether is everything still as it was when it was handed over. So that is a process that was followed thereafter. And upon agreement, then the dockets were signed off back to the task team as in the same form as they were handed over.
And would it be correct for the Commission to understand that a full audit then was conducted on those dockets, and that there could potentially be a report, an audit report available regarding the matters you've just addressed?
That is correct, Commissioner. A full audit was conducted. Commissioners are going to pay attention. You're going to see later when the audit report is produced that is going to perhaps, as the team are discussing between the head office and the task team, that the number of dockets differs. Differs in the sense that it is not 121, but it's 123. The counting rules of the task team is that when they have a case that involves, which is a priority as per the criteria, typical example, a political leader was killed, a case is registered. And through the investigation, they pick up that there's another docket that is linked to perhaps the suspect or the weapon that was used, it becomes a parallel case. So they take that docket and they merge it with the main one. So it becomes a sub-docket to the main docket. So when the team counts, they count the main docket, they don't count the second one, because it's a parallel investigation. It might they talk about 121. But when this audit is done and the head office team who did not understand the counting rules, they then said, but there is additional 2 dockets that are inside other dockets, which therefore means there must be additional 2, which makes the number to be 123. So there was then a discussion and explanation between the team that our counting rules, we count the main docket, we don't count the second one. But when they were scanned to be handed over to head office, even the sub-dockets were scanned. So everything was as it was handed. So the report will reflect that. I thought I must bring that to the fore so that there's no confusion. But an audit was conducted and finalized, and the report was produced as such.
Thank you. Thank you, General. At paragraph 141, you draw the conclusion based on the analysis that the team conducted and reported to you on, that no investigations were done on any of the dockets. Do you see that?
Yes, I see.
At paragraph 141. At paragraph 142, you give examples, an example of the extent to which there was a complete failure to advance any of the dockets from the time they were taken until they were returned. Could you speak to what's in 142?
Commissioners, what I'm trying to reflect here is that as a police officer who knows about the criminal investigations, once a case docket has got an instruction from court to arrest a suspect, and such an instruction must be carried out with speed. Now, for the period when these dockets were handed over to the head office, there were 5 of those dockets that had instruction to arrest suspects. Because the instruction came before the execution of those arrests, those dockets sat amongst the total dockets in the head office, and those arrests were not effected. What is more troubling about this is that the head office detective services had conducted some inspection on these dockets, as I indicated yesterday. In their inspection, they will have seen, and they even confirm some of them through the entries that they make, that the investigation is complete on the docket and suspects should be arrested. The least that they could have done is to take the dockets and go and look for that suspect and arrest the suspect. The reason why it was not done, I would not know. They were in a better position to explain. But I believe perhaps it could be that they were not familiar with the case, that the content of the docket itself. So it was going to be difficult for them to execute an arrest on something that they don't necessarily know, based on instruction of the prosecutor, because the docket, some of them are in volumes, and is quite a lot of information inside those dockets. So the 5 that had instruction, those instructions were not carried out. That was an easy thing to prove that there was work done on those dockets. But as the team were auditing it, they could realize that the investigation work was not done on the dockets.
I think you've clarified something I wanted to get clarity on. You referred to an instruction to arrest coming from the court, and I wanted to just get clarity on that, because I cannot see a court giving that kind of instruction. But later, as you went on in your testimony, you referred to a prosecutor. So did you mean an instruction from a prosecutor to arrest?
Yeah, well, when we talk court in our language, Commissioner, we combine both the NPA and the judiciary. So when we say the docket is gone to court in our language, when you say the docket gone to court, it does not necessarily mean it's been placed on the roll, it means it's gone to the prosecutor.
Court building, so maybe that's something historical. But you've clarified it. Thank you very much, General.
Thank you, sir.
Thank you, Chair. Thank you, General. And that you were dealing then with your paragraph 142. What's in 143 is, I think it's a point you raised yesterday, that in this intervening period, you were receiving inquiries from families, concerned members who want to know what is happening with the investigations. That then leads us to the start of today, which is at paragraph 144. We are now at page 49, and I would like you to read paragraph 144 into the record, and you refer to an annexure in that paragraph. We'll thereafter move into the annexure that you reference, because there's significant work to be done, to work through in that annexure. Thank you.
Thank you, Commissioner. Paragraph 144 on my statement reads, the immediate and adverse impact of the dissolution of the task team cannot be overstated. This is amply and succinctly set out by the Director of Public Prosecution, Advocate E. Harrison, in her letter that was written to me on the 10th of June, 2025. Advocate Harrison points out that the benefit of case coordination efforts under the auspice of the task team, of which the NPA is a part, which have led to numerous successful prosecution, will be lost as the individual dockets will have to be returned to their respective areas where the crimes were committed. On the happening of such eventuality, the dedicated prosecutorial team, which had been established by the NPA, will have no further role to play and will have to be dissolved. I annex here to Mark MK12 a copy of this letter.
Thank you, General. Commissioners, that letter is starts at page 194, MK12. And also, General, if you could turn to that annexure, 194. Thank you, Chair. Perhaps I should warn that this is going to be the main annexure we work with. But as we deal with the issues reflected in this letter, which are many and varied, we'll be cross-referring to other annexures. So I hope it doesn't cause confusion, because we keep our finger on this annexure as we go into another until we move on. So we never close the page on this. For the record, if you go to page 198, General, there's one small paragraph there, a signature above a name and a date. Could you read the name, designation, and the date as appear on page 198?
Advocate abbreviated ADV E. Harrison, Director of Public Prosecution, KwaZulu-Natal, dated 10th of June, 2025.
Thank you. If we start then at the beginning of that letter at page 195, Advocate Harrison starts her letter by stating the following: your correspondence dated 22nd May 2025 refers. The contents thereof are noted. Do you confirm that you communicated with Advocate Harrison in 22nd of May 2025?
That is correct, Commissioners.
Commissioners, that particular letter is not an independent annexure for General Mkhwanazi. It's part of annexures that Advocate Harrison has annexed. We can find that letter at page 244. In order to Have you found the letter, General? 244, thank you.
Yes, ma'am.
In order to appreciate then the response that follows in Advocate Harrison's letter, your letter is very short, could you please read your letter into the record and we understand what issues you had raised with her that invite a response, this lengthy response she's about to give?
Commissioner, on the date on the 22nd, I wrote a letter, 22nd of May, I wrote a letter addressed to the Director of Public Prosecution with the heading Political Task Team Prosecution Guided Investigation, Failure to Execute the J50 Warrants. In the letter, first paragraph reads, "This office wishes to apologize for the failure in executing the J50 warrants in dockets amongst 121 case dockets that this office has discovered to have been delivered to Pretoria due to a telephonic instruction received by the political task team leader. It is an unfortunate situation that this office became alerted to on the 20th of May in a docket accountable session to the fact that all prosecution guided since 2025-03-26 has not been addressed. This office assures the Office of the Director of Public Prosecution that the whereabouts of the docket is being investigated and the findings will be brought to your attention."
And the date you reference in that letter of 20th May 2025 is the date on which you learned officially in a meeting that the dockets, in fact you learned, not officially, you first learned that the dockets had been removed from KZN.
I became aware on the 20th of May.
Yes.
And I wrote this letter to the Director of Public Prosecution on the 22nd.
Okay. Now let's get back to our page 195, which is Advocate Harrison's actual letter. I would like you to read the second paragraph that starts with "kindly take note" into the record, and we understand what Advocate Harrison is communicating to you in response to your letter that we just spoke about.
On the response from Advocate Harrison, the paragraph reads as follows: "Kindly take note that the purpose of this correspondence is related to the issue of whether the political task team continues to exist. There have been a number of media reports whereby it has been noted that the political task team has been disbanded. There has been no formal communication to the Office of the National Director of Public Prosecution as well as my office on this issue. It is of concern that this office remains unsure of what the correct position is regarding the existence of this team. A Miss Mary DeHaas has been very vocal regarding the disbandment of the task team and the fact that it continues to operate. My office has had to indicate to her that I have received no formal correspondence regarding this disbandment. Despite this response, the concern continues to be a problem."
Thank you, General. If we can then sum up. We know from your evidence yesterday that you, as the provincial commissioner and the head of the political killings task team, never received any formal communication regarding the decision to disband. Am I correct?
That is correct, Commissioner.
And we learn from now Advocate Harrison from the KZN DPP that neither was the National Director of Public Prosecutions informed, and that she confirms she too, as the head of the KZN DPP, was not informed.
That is correct, Commissioner.
She then, at the third paragraph, informs you of how she has dealt with the matter, and I would like you to read that into the record.
I engaged Advocate Zaba regarding the content of your above-mentioned correspondence. He has confirmed that members were sent to his office to collect the dockets. My office cannot ignore an instruction when members are sent to collect dockets, as same is the property of SAPS. Upon inquiry regarding the existence of the task team, there was no clear response except that he noted that members of the task team have indicated to him that they will finalize the outstanding cases on the court roll. This is the only information that my office has regarding the issue.
And if perhaps we go over leaf and we read the first paragraph.
In 2026, there will be local government elections. We are aware that all elections are preceded by violent political activity. This consists of murder, attempted murder, assault, criminal injury, malicious injury to property, etc., being committed. The modus operandi differs in that it may involve members from the same political party against each other or between the different political parties.
And if I may just clarify your understanding, yesterday the chair inquired from you what you meant by intra-party killings. Would it be correct? I think your response was that there are killings of each other by members of the same political party. And this is what she references when she says killings involving members of the same political party.
That is correct.
Thank you. My reading of the letter thereafter then, from the second paragraph, Advocate Harrison gives a history of the NPA's involvement, KZN, in the task team before she draws some conclusions at page 197. And it's important that we work through the steps that she has set out in this letter. And this is when we start cross-referencing the many annexures. She starts her second paragraph with the wording, upon my assumption of duty in the province as the Director of Public Prosecutions in May 2019, parentheses, acting in at that time, close parentheses, my office was approached by General Kumalo, who requested for dedicated capacity to respond to the political task team. Do you see that?
That's correct.
The General Kumalo referenced here, is it the same General Kumalo we spoke of yesterday who you said was the project leader of the task team?
That is correct, Commissioner.
And the body of that paragraph, she references a document dated the 13th of June 2019. She has marked it as Annexure A. For the benefit of the Commission, that document, which is Annexure A to Advocate Harrison's letter, is at page 199. So if we could turn to page 199, General.
I'm there.
The top right-hand corner of that document is dated the 13th of June 2019. It's on the letterhead of the Director of Public Prosecutions, KwaZulu-Natal, and it's dated all DPP, KZN members of staff. In respect of that document, she says at page 198, we don't have to go there, I'll just remind, because of the increased workload and the demand for prosecutions, this led to my office, Advocate Harrison's office, issuing a directive to the KZN prosecutors dated 13 June 2019, and that is the document we are now looking at page 199. The document at page 199 highlights the issues that I think you testified to yesterday. In particular, from paragraph 2, it notes the high levels of violence, particularly linked to political persons or perpetrated by persons linked to political parties. That was then in 29. At item 3, she references the establishment of the interministerial task team by the President in the same terms that you testified to yesterday. Overleaf at 200, that's a background to the directives that follow from item 5 at page 200. I would like you to read paragraph 5, so we can understand what the instruction by the KwaZulu-Natal Deputy Public Protector was to all prosecutors in the province.
Maybe just to correct, is the Director of Public, not
Director of Public Prosecutions. There are too many acronyms and I mixed them up. I'm sorry for the confusion, and thank you, General, for pointing it out.
Okay, on paragraph 5, it reads as follows: all cases involving offences either perpetrated by persons linked to political party or against a person's links to a political party must be considered by the chief prosecutor before the matter being enrolled. In potential high court matters, the provision of Circular 3 of 2000 still apply. Each cluster and unit or office must ensure that a complete copy of the docket is forwarded to my office in the most expeditious manner in compliance with 3-day rule, and the correspondence must indicate political related cases in the subject line.
So, if I understand that correctly, and I want to test if that is your understanding as well, she is prescribing a process that must be followed regarding these political killings cases.
That is correct, Commissioners.
And that those cases require consideration by the chief prosecutor.
That is correct, Commissioner.
She then goes to, we jump to paragraph 8, listed 8, still on page 200, if you could read that.
The decision not to prosecute a person, but to use such a person as a witness in terms of Section 204 of the Criminal Procedure Act must be made in consultation with the Chief Prosecutor and or the DOPP in potential high court cases, or the DDPP, I beg your pardon, in potential high court cases. Section 204 should only be used in exceptional circumstances where it is in the interest of justice to use the provision. A reference must be made to Part 4 of the NPA Policy Manual, Section D, headed Section 204 witnesses.
So then, and once again, to test my understanding and to see if it accords with yours, that item 8 seeks to institute a process to manage the Section 204 witnesses process.
That is correct, Commissioners.
I then would like you to go to read item 10 on the same page.
No politically related cases may be withdrawn without detailed and cogent written notes in the C clip of the docket or office file.
So there was a requirement that in respect of the cases that the task team was dealing with, should there be a decision to withdraw against a suspect, that must be done only after a detailed and cogent written report is filed in the docket.
That is correct.
Then we go back to 196, main letter. And we're at paragraph 2. At paragraph 2, it concludes, this directive set out the challenges which General Khumalo had raised. Despite this arrangement, there was a continued unhappiness regarding the task team not having dedicated capacity. So that was, it would sound like the DPP's attempt to address General Khumalo's concerns and challenges in the province. And she concludes here that even that was not enough. Is that your own understanding as well?
That is correct.
She then looks at a different issue at paragraph 3 and says, I also wish to bring to your attention a correspondence with the Minister of Police, Mr. B.H. Cele, or which the Minister of Police, Mr. B.H. Cele, had forwarded to our NDPP advocate Batoi. This correspondence is dated 24th of May, 2019, and she states that the purpose was to highlight the challenges regarding the successful prosecution of politically related cases allocated to the task team. In this regard, she refers to a document she calls Annexure B, and that, commissioners, will be found at page 202. And General, if we could turn to page 202. Now, it's a fairly, well, not too long, but it's about 6 pages. So if you could just quickly flip through that document and tell the commissioners what that document is. Then we will work through the detail of the document.
It's an NPA internal correspondence from the Director of Public Prosecution in KwaZulu-Natal, I beg your pardon. It's addressed to the Advocate Batohi and is from the Minister of Police. If I had to check the signature part of it, which is at page 209, it was signed by Minister of Police, Mr. Kwele, on the, I think the date is 24th of the 5th month, 2019. It's just written, it's not quite clear exactly the date, but it's a letter from the Police Ministry to the National Director of Public Prosecution.
Yes. And this letter is shared with you by Advocate Harrison.
That is correct.
DPP. Let us consider the contents of the letter. And we do so, we start at page 203. And I take it that you would be familiar with the facts set out in this letter, in this document, because on my reading, this letter refers to politically related killings in your area of jurisdiction. Is that a fair assumption?
Yeah, that's correct.
Let's look at the challenges at page 203. The letter highlights challenges identified, and at item 3. At item 3.1, he references section 204, witnesses killed while in the witness protection program, and he gives an example below that. You confirm that?
That's correct.
At item 3.3, same page, the heading is section 204, witnesses turned against the state. And at subparagraph 3.3.1, witnesses who abandoned witness protection program. Can you shed light as to what he's talking about, the minister is talking about there?
Commissioners, I must indicate that, as I've indicated before, that the IMC will be receiving briefing from the team. So part of the briefing to the IMC will be to indicate challenges that the team will experience. And some of these challenges are the ones that are listed in this letter. A typical example of a witness that will turn against the state will be a person that will have a first-hand information. It could be the person was part of the commission of a crime and turn witness, and a person who was involved, directly involved. But because of the delays and challenges, maybe that person is approached by the main suspect. In the hierarchy of this organized killing, you'll find a person who's controlling the purse, a person who's got the money, will coordinate this killing, will not do the job himself or herself, but will pay someone to find a hitman. So even if we arrest a hitman, the person who hired the hitman who have received money is the one that maybe turns out to be our witness. But if that person is compensated somehow or is persuaded somehow not to assist the police, and that's a person who then withdraws his services. But there are reasons of withdrawal, obviously differ. At times it could be through intimidation that leads into that person turning against the state.
And on the same document, the same page 204 on our, no same, overleaf 204, item 4. There is a table there that flows over to page 205, and that table is headed questionable withdrawal decisions by the NPA. And commissioners, we apologize for the poor quality, but to assist, the first column reads station and case number. The second column reads decision, and the third column reads prosecutor. So this table sets out the details of specific cases and the decisions
The second column?
Decision.
Decision.
So it's a summary of the decision, or the basis on which they put forward for the withdrawal of the case. And the last column indicates who the prosecutor was in that matter. So it's called prosecutor there. It's a list of of 11. And just to give the commissioners perhaps a flavor of the issues that are raised, which lead the drafter of this document to call them questionable withdrawal decisions by the NPA. We will not highlight the names of the prosecutors who were involved. We'll just concentrate on some of the reasons advanced for the withdrawal. So I will ask you to read the reason in respect of case 1.
On case 1, the reason suspect placed on the roll and later withdrawn.
And that was a murder case, according to this document, column 1.
That is correct.
The next 2 cases were for intimidation. They too were withdrawn. And please read into the record the reasons advanced for the withdrawal there.
The reasons advanced by the prosecutor here, I quote, "You will feel the heat does not amount to intimidation, which resulted in all 3 cases being declined to prosecute."
Then I will turn over to page 205. Again, I pick a different one. Item 9, that was a case of unlawful possession of a firearm. Please read that reason, the reason advanced for withdrawing that one.
The owner of the security company does not cooperate to rectify the queries regarding the investigation.
And lastly then, item number 11. This is in respect of possession of unlicensed firearm and ammunition.
Unreasonable demanding additional evidence to enroll the case despite overwhelming evidence which link the suspect to the case.
Yesterday you testified to the novelty of the task team approach in investigation.
Sorry, before you do that.
Yes, yes, ma'am.
Ms. Silo, just so that I make sure I understand, the reasons where it says decision in that column,
Yes.
are these the notes of the prosecutor, or this is Minister Cele saying it's unreasonable to demand additional evidence? I'm looking at your example 11, right, where it says unreasonable demanding additional evidence to enroll the case despite overwhelming evidence which links the suspect to the case.
Yes.
Is this the prosecutor saying that, or it is Minister Cele raising his concern about the decision not to prosecute?
No, my understanding of the table we've gone through, as if we consider it in the context of the heading, questionable withdrawal decisions by the NPA. So the decision to withdraw has been taken by the NPA, and the issue is that the reasons advanced for the withdrawal are questionable. So that column that is headed decision seeks, as I understand it, to highlight the reason that was advanced at the time of withdrawal. So I did not read this table to include any personal input or opinion by Minister Cele.
Okay.
He was just reflecting what is already on
What is
record
recorded. Okay.
regarding these decisions by the NPA.
Thank you.
Thank you.
This is still confusing, though.
Okay.
Because I cannot see the prosecutor saying that they unreasonably demanded additional evidence. So probably it's the minister here expressing his own view, and maybe what happened is that it was the prosecutor who was insisting on additional evidence. And so the minister is expressing his view that that was unreasonable because there was sufficient evidence. So this one sounds to be an exception to what you are saying, which is what's in that column is the decision as was recorded. But
I would perhaps ask that we park the issue for the moment. As we work through the document, we will realize that the minister technically is quoting the information that became available to him regarding all these issues. Because sometimes it gets so specific that is information he simply could not have. So clearly the source of the information, he is reflecting the situation on the ground. He concludes at page 209 with the findings and recommendations. So I understood that document and the table set out therein not to be expressing his view.
perhaps to save time, let's
Yes.
just say my co-commissioner, Commissioner Baloyi, did raise this, and let's just leave it at that for now.
Indeed, I hope by
Yes,
the time we
yes.
get to the conclusion of this document,
Yes.
perhaps then we'll have a better understanding. Maybe just a question of how it's expressed.
Yes,
But it would seem to suggest that the last column gives you the name of the prosecutor who was involved. The second column gives you the reason why it was withdrawn. This particular one seems to have a comment that it was unreasonable. The case was ready to go to trial, but there seemed to have been further demand for evidence. Now, it may potentially mean that the prosecutor himself was refusing to take the matter to trial and demanding more evidence, when in essence, practically, the matter was ready.
Yes, and then
Yes.
someone else says that was unreasonable. And because this is the minister's document, it's on that basis that we think
That it might be him.
is the minister expressing that opinion. But as I
We
said,
can flag
in
it.
the interest of time,
We'll find out exactly where that comes from.
yes, let's move on.
The next table, still on page 205, deals with what the author calls the questionable decisions by the NPA. And the headings there are, once again, case number and the charge, and the second column should read decisions. Here, there are two cases, two murder cases. And if you could just quickly highlight what under the column decision advanced in respect of each, General.
The first case is Ntuzuma case 242 of 10/2012. It's a murder case. The NPA guidance to take the case for formal inquest instead of trial, despite strong evidence of premeditated murder. The second one is Plesisler case 2335 of 2018, murder. Unreasonable demanding additional evidence to enroll the case despite overwhelming evidence which links the suspect to the case.
And just for completeness, then at page 206, it's a similar table, but this time it speaks to speedy trials delayed. Do you see that? And
Yes.
it follows the same format. It gives you the name of the accused, the case number, and then the decision advanced. Would I be correct to suggest that all these are matters that the task team at the time, regard being had to the fact that this is generated in 2019, that the task team was concerned about, which is delay in prosecuting matters that have been investigated? Would that be a correct understanding of this document?
That is correct.
Then if we go at 207, under item 8, accused granted bail whilst on bail. Now that goes over till 208. Starts at 207 into 208. We don't have to read them. You could choose an example to highlight what the concern is here about accused being granted bail whilst on bail. There are 6 instances, I think, that are quoted in the letter. We'll deal with any one of your choice.
Yes. 8.1 Sifiso Khadebe, a well-known hitman, was arrested on IB's case 91 of April 2017. Murder of Councillor Tobela was granted 10,000 rand bail. While out on bail, he committed another offences as per AB's case 869/2018, the discharging of firearm, and was granted 1,000 rand bail. Mzimkulu case 5 of 10/2018, possession of unlicensed firearm, granted 1,000 rand bail, and Mzimkulu case 112 of 10/2018, possession of unlicensed firearm and ammunition, granted 2,000 rand bail. Bail was opposed on all cases, but it was unsuccessful.
So the situation is you have an accused, they are charged, they are arrested, they are granted bail, they are released. And then another case arises, they are arrested, they apply for bail, and they get a second bail, and so it goes. It sounds like it's 4 bails on top of the first. Is that correct?
That's correct.
Do you agree with what's written at page 207, that that is a concern for you as the head of the political task team, as a member and as a police officer? Is that a concern? And if so, why?
It is a concern indeed, as I said earlier, that this will have been an extract of the briefing that was given to the IMCs about the challenges that we're experiencing with regard to the prosecuting of these cases. That when a person has been accused of a serious murder case, arrested, granted 10,000 rand bail, and you commit other serious crimes thereafter of possession of firearms, but still given bails, it simply means that the court is not taking serious the risk that this individual has in society. That if he keeps granted bail because of murder and is arrested with a firearm again, and is granted another bail, and again arrested because of the firearm charge, and granted bail again, it simply means that he is allowed to go out there and carry a firearm and do whatever he wants to do with the firearm. The court does not see the need of stopping this person from doing that. And this has a serious consequences towards the witnesses and many other people that are involved on cases that this person is arrested for.
And perhaps for the sake of completeness, let's look at case at page 208, which is a slightly different case, but along, in the same vein, under item 8.6, if you could read that.
Fisokuhle Ntuli was arrested, charged, and sentenced on Patfontein case 50 of June 2016 for 4 times attempted murder charges. He appealed and was granted bail. Whilst on bail, he was arrested and charged on 4 murder cases, as per Nongoma case 30 of April 2016, 391 2016, also Nongoma, 88 Nongoma, as well as 127 Nongoma, all of them in 2018.
Yes.
And possession of unlicensed firearm as per Nongoma case 285 of 2017, and Nongoma case 147 of 2018 June, that he is alleged to have committed while on appeal.
So this accused is actually charged, convicted, and sentenced, then he appeals. He's granted bail while he's awaiting his appeal. And in that period, manages to commit 4 more murders.
That is correct.
Okay. Now,
Manages to be charged with a commission of...
that's more precise, legally correct, yes, manages to be charged. Then I think what we have just worked through, which was what Minister Cele at the time communicated to Advocate Baktoy, culminates in certain findings and then followed by recommendations, and that's set out at page 209. I think it is important to appreciate the findings made in 2019 because that gives a sense of the situation as it prevailed in 2019, appreciated even by the minister. So if you could read the findings under item 9 at 209.
Findings reads as follows. The political related cases, especially murder, are organized in nature with different role players carefully identified, that is hitmen, spotters, coordinators, and individuals at the top who are ordering the hits. Bullet 2, most cases are dependent on Section 204 witnesses that were part of the syndicate, especially when the investigation has to be directed against individual on top, open bracket, politicians and entrepreneurs, close bracket. Bullet 3, the involvement of politicians and business people possess a threat of attempts to bribe the criminal justice system personnel. If it fails, then attempts to turn Section 204 against the state. If that fails, then they kill the state witness, which results in the case being withdrawn. Paragraph 4, bullet 4, the lack of dedicated prosecutors to guide and prosecute on allocated cases. Bullet 6, bullet 5, I beg your pardon, the trial-ready cases being postponed for a longer period due to unavailability of dedicated magistrates. The last bullet, the repetitive granting of bail to accused who are already on bail.
Yes. So those were the findings that Minister Cele drew at the time. Did they accord with your experience and knowledge with the situation as was prevailing in KZN at the time?
That is correct, Commissioners.
And he turns then lastly at item 10 by making recommendations to Advocate Batoi. If you could just quickly read those into the record.
Recommendations, 4 of them reads as follows. Bullet 1, a dedicated courtroom for the processing of the politically related cases. Bullet 2, dedicated preferable prosecutors and magistrates to deal with these cases. Bullet 3, appointment of a permanent KZN Director of Public Prosecution. Bullet 4, urgent appointment or utilization of police officials to fulfill the function of the security officers in the Witness Protection Program as prescribed in the Witness Protection Act 112 of 1998, Section 3, 5A, Roman figure 3, and Section 6B.
And he concludes the letter. Now we go back to...
Mr. Law,
Yes.
before you leave this letter, you asked the General whether what is under the findings in those bullets
Yes,
accords with his knowledge and experience at the time.
indeed.
And he's answered in the affirmative. I want to ask a question, but I don't want to anticipate where you're going to go. I would have done a follow-up of, as at the date of the letter which disbands or that seeks to disestablish the PKTT, which is what, in December, these factors in bullets 1, 2, 3, under findings, what the position was. I want to ask that, but if you are going to be dealing with it in your own way, I don't want to interfere with it. So
Well,
you stop me.
There would have, we were prepared to deal with it in another way,
Okay.
but it doesn't change the course of anything.
Okay.
It can be dealt with now. Now that the Commissioner has put it out there, perhaps the General
You can
respond
deal
to
with it. Okay.
No, the General can respond to it
Yes,
immediately.
General, you've had in 2019, you say that you were aware of those factors in bullet 1, 2, 3, And these are the politically related cases, especially murder, are organized in that way described there. Most of the cases are dependent on Section 204 witnesses, and then bullet 3, the involvement of politicians and business people. Is at 2024 when Minister Mkhunu sends the letter or the instruction to disband the political killings task team. What in your impression and experience is the position? Is it still the same? Is it any different?
It remains the same, Commissioner, that there is a lot of interference with these investigations in different forms, as is listed there, in order to try and close these cases by business people and politicians. And by and large, because they are political cases, the people on the higher level of the syndicates that are involved are the ones that are behind the closures of dockets. So they influence the docket. It still remains the case to date.
Thank you, General.
Thank you, Commissioner Baloyi. We go back then, General, to Advocate Harrison's letter, and we were at page 196. And we're looking at the last paragraph. I invite us to consider the last paragraph of that letter at page 196. And she states on 23rd August 2019, there was a steering committee meeting. There was a presentation done, and that presentation she attaches as Annexure C. For the record, that annexure appears at page 210 of file 2. However, that copy is not the best, and I would just for the record like to point out that it is the same plan that General Mkhwanazi dealt with as MK5. No, I make a mistake. We are at 210. Then it's the next one that I ran ahead of myself. We are dealing with Annexure C, the one at 210. If you could turn to that document, General.
Yes, I'm there.
Advocate Harrison says this was dealt with at the steering committee meeting. And it's headed Progress Report, Investigation and Prosecution of Investigation and Prosecutions of Political Related Cases, Steering Committee, 23 August 2019. Now, yesterday morning, you recall when you informed of the establishment of the task team, you highlighted the various governance structures of the task team, and the chair even asked you about the National Steering Committee. My question is, the steering committee referenced here, if you could look into the content of that document, do you know that steering committee? Is it in any way related to the task team, or is it a different steering committee?
It's a steering committee related to the task team.
So this is this task team steering committee. She goes on to say that, perhaps before we deal with that, let's look at that report at page 220. There are recommendations. Is my understanding correct that this is what is being recommended by the NPA to the task team for adoption?
That is correct, Commissioners.
Can we just quickly read that and understand what was being recommended? And for the record, I know that this is 25th August 2019. If we refer back to the minister's letter, that is from May of 2019.
There are 4 recommendations, Commissioners. The first one, dedicated courtrooms ×2 for the processing of the political related cases, 1 serving the central and northern regions, and the other court servicing the Midlands and southern regions of the province. Recommendations 2, dedicated prosecutors ×6 and presiding officers ×3, preferable from outside the province to deal with these cases without delay, fear, and compromise. Third recommendation, the use of dedicated correctional center, in bracket, Epongweni, Kokstad, super maximum prison, close bracket, already identified by the Minister of Justice and Correctional Service for accused of politically related cases to minimize the risk of interferences. The last recommendation on bullet 4, utilization of police officials to fulfill the function of the security officers for state witnesses on political related cases who are on the Witness Protection Program as prescribed in the Witness Protection Act 112 of 1998, Section 3(5)(a), Roman figure 3, and Section 6(b).
Thank you. To your knowledge, this being a presentation to the task team and the recommendations are being made to the task team, were these recommendations accepted by the task team?
It's recommendations that were made which to some degree were accepted, except the challenges that were expressed regarding the dedicated presiding officers on the matter, which will require the Department of Justice, the courts especially, as although the minister was part of these meetings, but there was no magistrate, chief magistrate as part of the team. So that is what then the NPA was going to escalate to the court.
And before at least the 31st of December 2024, what was the prevailing position within KZN insofar as these recommendations are concerned? What had been implemented after the task team accepted some of these recommendations or were able to implement them?
I must indicate, commissioners, that when the team was working up until that period, there has been challenges in some of the presiding officers which led into one complaint against one presiding officer, magistrate, that was registered through the right channels for investigation.
General, I apologize to interrupt. Can we give the commissioners a moment? You're not? Okay, thank you, Commissioner. You may proceed.
I was still saying that there had been some challenges with some of the presiding officers in handling these matters of the task team, which led into one complaint that was registered in Pietermaritzburg against one of the presiding officers. But by and large, the close working relationship between the SAPS and the prosecution team on these cases, the involvement of chief prosecutors as directed by the Director of Public Prosecution, of which I must say when we started she was acting and she became permanent. And when she was permanent, then the structure started functioning well, which happened after the letter of the minister's request to the NDPP. And when the structure started working well, then we started seeing cases being enrolled in court, cases not being postponed for a lengthy period as it used to be before, and majority of cases are being finalized in court within a short period of time. So the improvement, the performance of the courts supports the investigation, and the team is satisfied at this present moment with regard to how the matters are handled in court, and also how the prosecution is involved in guiding the team. And those concerns that the minister had read in written in the letter, which was referred to earlier to the NDPP, citing the challenges that we're experiencing with regard to the decision of prosecutors on matters that we are presenting before them, has been eliminated in that as we are investigating, the prosecution is part of this investigation. So by the time we get to court, we are ready for prosecution. Unlike before when we were raising these concerns, that we're investigating and then hand it over to the prosecutor, and the prosecutor might want to withdraw the case, citing different reasons that made the investigation team to be unhappy. But that has been mitigated by this close working relationship between us. So the situation has vastly improved as a result of these dedicated prosecutors that are part of the team. And also the involvement of correctional services as reflected on the third one. As the Minister of Correctional Service and Minister of Justice and Correctional Service, had indicated that the maximum prison of Kokstad would be made available, and as well as a close working relationship between the other facilities in KZN. That has made it easier for the detention and the control of access to the suspects in those detention facilities. And the courts are playing, the correctional facilities are playing a critical role in also monitoring the activities that are happening around the people that are arrested. Visitors that are coming to see them, they're able to share with the team that there was this person who came to visit the person that has been detained. And that allows the team to investigate further the involvement of those people, so that it helps us to link them to such a person. There's been a lot of success as a result of that, which we thank correctional services for playing that critical role to help with this investigation, not only just to detain the people, but to assist also with the interviews, making the facilities available for the team to have easy access to correctional facilities to allow the team to be able to investigate.
Thank you, General. Before we move to the next point, Commissioners at 196, when I confused myself because I ran ahead, please make a note for yourselves that the annexure D referred to there, it appears at page 223. It is in black and white, but it's the exact document that we have as MK5, which is in color and therefore more legible. If then we could turn over to page 197, General. And I invite you to read into the record paragraphs 2, 3, and the one-line paragraph, no, in fact, 4 and 5, before we get to conclusion. So you can skip the first paragraph on that page. I would like to draw attention to the second paragraph. If you could read from there to just the last paragraph before the heading conclusion. Thank you.
All of the above indicates the amount of work which went into ensuring that the work of the political task team was coordinated so that there was better case coordination and management of same by NPA, but above all, to deal with the prosecutorial challenges that the team and the Minister of Police has raised to the NDPP. I was instructed to have a dedicated prosecutorial capacity which was provided as per the request. The dedicated prosecutorial capacity is headed by the Deputy Director of Public Prosecution, who has advocates under his management who are assigned to guide the investigations, make prosecutorial decisions, and prosecute these matters where there are murder and or attempted murder charges. A database has been retained since the inception of this dedicated capacity. There have been numerous successful prosecutions. There are several high-profile political-related matters or cases on the court roll. Some are in High Court and others are in Regional Court. The dedicated prosecutors continue to provide their prosecutorial dedication to these cases. However, they are also not certain as to what is the position regarding the existence of the team and new cases reported. The task team has its own resources, which assisted with the fast-tracking of the investigations. All of the information above has been set out to show the seriousness that this office made to address the challenges which the task team and SAPS as a whole had raised.
I understand from what you've just read that it is the Office of the DPP speaking through Advocate Harrison about the concerns on the part of the DPP and the NPA office as regards the so-called disestablishment of the task team and the loss of effort made since 2019 to address political killings.
That is correct, Commissioner. As the head of the prosecution in KwaZulu-Natal, she was expressing the concern that not only affects her only, but the prosecutors that are working with the team.
And then she draws conclusions. And if you could just read that into the record, please.
It is requested that you assist with providing my office with a response regarding whether the SAPS political task team still exists. The dedicated capacity needs to respond to the dedicated task team. If there is no dedicated task team, then the dedicated prosecutorial capacity will be dissolved, and all new cases will have to be reported to the chief prosecutors in the area where the crime is committed. This office cannot retain dedicated capacity where there is no dedicated SAPS task team. Your correspondence will assist as the unit has to plan for the year 2025-2026. It has its own priorities as per the NPS AOP. As we are all aware, organized crime has become the new focus or priority, and this office needs to plan. I am unfortunately not able to complete the planning because the issue regarding the existence of the task team has not been communicated. At this stage, the only information which one has is that in the media. Your urgent response to the above issue will be appreciated. Signed by Advocate Harrison, dated the 10th of June, 2025.
And that the signature is as Director of Public Prosecutions, KwaZulu-Natal.
That is correct.
Just for the record, this letter is addressed to you. Did you have opportunity to respond thereto?
Beside a telephonic conversation that I had with her, I did not formally respond to the letter, Commissioners, because it was a time when I was busy trying to intervene with regard to the decision of the minister to dissolve the team, trying to facilitate that this decision must be reversed in order to mitigate these challenges, which of course it had not happened, and I can safely say without jumping forward that the further engagement we've had with the DPP in relation to this and the decision of the team has led into the criminal case docket being registered, which we cannot discuss it now. It's subject to all this which has happened.
Sorry, Advocate Silo. General, having regard to the content of this letter, can you just tell us whether you shared similar concerns as those expressed by Advocate Harrison in the letter?
That is correct, Commissioner. Commissioner will recall that when she starts her letter, she refers to my letter to her. In my letter to her, I'm apologizing for the failure to carry out her task, instruction of arresting that we have failed to do as the police, and explaining the challenges as a result. That's why then she's writing, expressing the same concerns to me. Really, what she summarizes on her letter are the concerns that the team shares with the prosecutors that are working under her. So she's just elevating that to bring it to my attention so that I can, when I engage with my principal, be able to show what the prosecutors are saying with regard to this decision of the minister.
And then the consequences going forward. The letter also mentions new cases and what consequences will be in relation to new cases going forward.
That is correct. The engagement I have with her was that as and when the cases are coming, we will still allocate them to the team, and I will still expect the prosecutors that are dedicated to continue. The fortunate position that we are in is that although some of these 121 dockets were taken to Pretoria, quite a lot of other dockets were still in court. And the very same prosecution team was involved in those dockets. So they are still engaged with the team on that level. Not necessarily taking new dockets, but they are still engaged with the team in as far as the courts, dockets that are in court. But as soon as we engage and then they understand that it is not the IMC that took a decision to disband, it is not the National Commissioner that took a decision to disband, the team is still on the ground, albeit that is not taking new cases. And what I'm starting to do as a complainant in this matter, by registering a complaint officially for criminal investigation and explaining to her from what we have discovered as to what is the cause of this instruction. And she took comfort in that of saying, then her prosecutors will remain in the team. She understands that this might be another crime that is committed on the side to try and frustrate the work that the team is doing. But as we explain later on our statement during this course of this commission, the picture is going to become clear as to why we end up continuing taking this decision of saying the prosecutors remain in the team, because there's an understanding of what is really going on that leads into this letter.
You referred to a case that has, quote unquote, been registered, but of course you said you are not going to go into any detail in that regard. But can you please just describe fully what that case is about?
Commissioner, it's a defeating the ends of justice case. There is an investigation that is underway.
You say you are the complainant in it, and the complaint being against whom?
The defeating the ends of justice case that I reported against the people that were involved with regard to the stopping of this investigation. I could mention the people that I'm suspecting, I'm accusing of this, but maybe it will be better, I'll be in a better position towards the end of my appearance before the commission that I could conclude and say, therefore, these are the people, after having put reasons as to why I'm pointing at them. If I put them up now, it might be a problem.
That's enough. I just wanted to get an idea of what the case is about, and that's enough for my purpose.
Thank you.
Let us take the tea adjournment and come back at 11:15. Let's adjourn.
Do you see why we couldn't?